right, I guess we'll get started. I think we've got several people online, and just in the interest of getting through all the presentation materials, we'll go ahead and get started and give people a few extra minutes to get logged in while we're making introductions. Good morning, everyone. My name is Sipra Boyd, and I am a shareholder out of the Houston office of Robert Markel Weinberg Butler Haley. Thank you so much for joining us today. I hope everyone is staying safe and healthy out there and trying to maneuver this new normal that we've got going on. All right, well, I'm going to go ahead and get started with some introductions. Like I said, I'm Sipra Boyd. Joining me today is Noelle Hicks, who is an associate out of the Houston office as well. I'm going to go ahead and kick off the presentation and handle the first part of it, while and then about halfway through, Noelle's going to pick it up from there and finish it off. We're going to do what we have in previous presentations. If you've joined us before, we're going to allow you guys to submit questions through the Q&A function of the Zoom portal. I think, I don't remember where it's located, either at the bottom or to the side. If you click that, you can submit a question while you're listening in. And we're going to just kind of play it by ear. If there's a question that comes up and I can do more than two things at once, I'm going to try and incorporate some of the answers throughout the presentation. If for some reason I don't get to it, or Noelle isn't able to get to it throughout the presentation, we're going to leave some time at the end to go ahead and answer some questions at the end. All right, our goals for today, we're going to talk about pre-qualifying vendors. And this whole process of pre-qualifying vendors it can be daunting in many ways, because quite frankly, there's so many vendors. So we're going to talk about setting expectations for the projects before you enter into them, and really having a good discussion with the board and the management company about what your needs are for the association and the project. There's also several nuances when you're trying to determine vendors that I think you'll be surprised to learn really should play a role in impacting how you determine which vendor to choose and what specifically you're looking for. So determining a company policy for contracting is important. There's also considerations regarding ethical behavior and what bribes might look like, and Noelle's going to touch on those towards the end of the presentation today. And then, of course, when you do select a vendor, part of the process is monitoring the project and what the vendor is doing for compliance, and making sure that there's a policy in place to check in and sort of manage the contract in one way or another. There's a lot of legwork really initially in trying to select a vendor, and like I said, it could be daunting, but I firmly believe that if both the board and the management team really sit down and look at the needs of the association for purposes of entering into a contract for whatever service is needed, that if you do some legwork at the beginning of the process, that it will actually save a lot of heartache and time, money, resources at the end. I can't tell you the number of clients that have come to us well after the pre-qualifying process, well after the contract's been drafted and entered into, well after work has begun, when lo and behold a problem occurs. And that really is the worst time to start looking at the vendor, the contract, and figuring out, now what do we do to enforce our rights under the contract because something's gone bump in the night. So again, this is going to sound like a lot of information, and this is all information that really is relevant before you actually sign on the dotted line. So this is even pre-contract work that you should be doing, legwork that you should be doing as a board and as a management company to make sure that the association's protected, that the members are protected, the board's protected, and especially its management team and any other vendors. So how do you find a qualified contractor? again, daunting tasks. There's thousands of contractors out there. And I think what is important to remember is in the POA industry, the Property Owners Association industry, it's a unique industry. You know, POAs are nonprofit corporations, and we have certain needs that, you know, single family residential properties might have that are different. And depending on the type of work, the contract, the needs, the potential for pitfalls, I think, I guess, barreling down and really sitting down and figuring out which contract is appropriate or contractor is appropriate, I know is a hard task. But I would certainly recommend a few things. Look for contractors that have experience working with property owners associations. We'll often find that, hopefully, if they've worked with one in the past or several in the past, that those property owners associations have also gone through the vetting process and asked the same questions and requested some of the same information that you're going to be asking, so that they've already done the legwork and are prepared to respond on a timely basis. So look for people and contractors that have experience with POAs. Always really important, and what I'm going to hit home in the first part of this presentation is insurance. Insurance is a really important part of any contract, whether it's for services or materials, professional services, whatever type of contract that you're entering into. If there is something that goes bump in the night, you're going to want to make sure that either the vendor is properly insured for the particular issue that's come up, and also to make sure that the association has talked with its insurance company in the event that, you know, the vendor can't provide proper insurance coverage, or maybe there are some holes or gaps in the insurance coverage. You always want kind of a second layer just in the event something, again, goes wrong and insurance is triggered. And then, you know, one of the questions that you would think would not necessarily be that mind-blowing is, will the vendor really want to sign a contract? And that's a funny question, but, you know, a lot of decisions and contracts sometimes are made over a handshake. And sometimes people think, well, contracts are complicated and lawyers get involved and they're unnecessarily long and you know, have provisions that maybe we don't feel like we need. A handshake's fine. It's a, you know, $5,000 contract. We're not going to worry about it. We're just using a handyman. Well, you know, as you know, lawyers are risk adverse, and even in a $5,000 contract with someone that you have a handshake deal over, things could go terribly wrong. The handyman could get seriously injured on the job, and depending on the contract, if you don't have a contract, depending on whether that handyman is insured or the association's insurance, you're looking at some potential problems and real liability as it relates to the association. So it's really important to even ask simple questions like, hey, once we get around to agreeing on what you're going to be doing, will you be willing to sign on the dotted line to make sure that that contract is enforceable? So the use of the term vendor or contractor that I've been using really encompasses a large scale of different types of services. Most often in the POA industry, I think vendors are often thought of as pool companies or landscaping companies. There's also, obviously, if the association has construction needs, contractors or vendors that are in the construction industry, and that could, you know, run from the general contractor that's just going to oversee it to subcontractors that are actually doing the work. And then I'll touch on professional contracts as well, lawyers, your accountants, CPAs, any vendor that's providing a professional service is also a contractor and a vendor that should be properly insured, and one with which you should have a contract that is enforceable. Again, if something goes wrong, or again, also if you just need to make sure they're following the contract and doing what was agreed to based on the contract price. Remember that not generally, I guess, everyone thinks the bigger the contract, the greater the risk. And that might be true. Certainly with, a $1 million contract, there's more money on the line and there's potential for more risk and liability for the association. But as I've stated, even in the smallest of contracts, there could be potential for problems. And it's really important, if you're going to enter into some type of service agreement with a vendor or a contractor of any kind, that you really take some time to run their references, check their insurance, see what they're willing to agree to in paper and be bound by. So just keep those in mind whenever you are contracting. So how do you find a vendor? There's obviously lots of ways, within the Google world that we live in. You can Google, Houston Pool Company, and thousands of pool companies will come up. I don't know that that's necessarily the best way to do it, but again, that's a start. You can start with a window of the 50 pool companies and then work your way down, or 20, whatever it is, whatever that number is. But keeping in mind that you want to try to work with vendors that have some experience in the POA industry. One other way certainly is word of mouth. For board members, I would rely on your professionals that you work with, whether it's your management team, your lawyers, any trade associations that you work with, to see if just by word of mouth, other associations or other managers have had good experiences with other vendors. And I think, not always, but if someone's had a positive experience with a vendor, that speaks highly. A referral is one of the best ways to, I think, give applause to a particular vendor, because if you had a good experience with them and you like them enough to refer them some more business, that should mean, in more ways than one, that they've done a good job, that they've held up their end of the bargain. So word of mouth is one of those ways, and particularly word of mouth in the industry. So I know, board members, a lot of our board members are professionals, and they have CPAs and legal degrees, and potentially also deal with other types of vendors and service contractors. And so, they might have experience with people that they've worked with on a personal level, not related to the association. And while I think that's, a fine way to potentially find a vendor, I would just caution that maybe shouldn't be the only way, and always be careful about potential conflicts of interest. And we won't spend a lot of time on that. That's probably a whole nother webinar or presentation, but you want to make sure that the director doesn't have some type of a financial interest in the company that you're contracting with. And it doesn't necessarily have to be as far as a financial interest. There could just be some other type of a business conflict. So you want to make sure that you're casting a wide net with trying to determine which vendors to use. I mentioned trade associations. CAI has Community Associations Institute, is an organization that our firm belongs to. And I know I've encouraged other board members and management companies to join as well. And CAI Houston, the website, which I believe is caihouston.org, has actually a service directory. And I think that's a helpful way to find vendors. You can just, again, go online and look at their service directory. And the service directory has vendors that are members of CAI Houston. And again, be careful with that. Just because they're a member, I don't know that that necessarily means that they're the best of the best. But I think that it does bode well that they are part of a POA specific industry trade association. And so again, they should have experience with working with associations, and that should be helpful. Every contract is different. I think that there are important parts of every contract that run across the board. So whether it's a pool company or a landscaping company, construction, or even a professional service, when I get a contract in my office that a client wants me to review, I'm going to look at some important parts: the indemnity provision, the insurance provision, the termination, the scope of the services to be provided. And so really important when you're pre-qualifying, again, to do the legwork at the beginning so that you're trying to cast a net that fits a particular type of service that you're looking for. You want to be able to, depending on which contractors you pick, be able to compare apples to apples and make sure that the contractors that you're getting information and prices from know what they're doing, have knowledge in the industry, and are essentially providing the same or similar service. And if not, then there is going to be a huge price difference, and I'm not sure how you can reasonably qualify one vendor over another if there's not a basic understanding. All right, so factors to consider, which I've really touched on already to a certain degree. Years in the business, that obviously the longer you've been in business, hopefully that means you're doing something right, and that should bode well. We're celebrating our 40th anniversary, so that's exciting. And, all of it has been in the POA industry in terms of how the firm initially started, although now we've become a full service firm. But again, I think that when you say you've been in the POA industry for 40 years, that means something. But again, also be careful. Some contractors, if they have been in the industry for too long, or a long time, I shouldn't say too long, maybe, they're not potentially keeping up with recent trends or changes. So you want to avoid a contractor or a vendor that maybe isn't keeping up with the times. And so even though, again, years of business is important, it's not necessarily the only factor. Adequate references. I think those are really important. I would certainly, ask board members and managers to ask for references, at least 2 or 3, and don't just ask for them, follow up with them. Sometimes I think, some people think, well, if I ask for them and they give them to me, that must mean that, they've done a good job, but you don't necessarily go through the legwork of calling the reference. Go ahead and make that phone call. You'll be surprised to learn something new or something relevant, that might make a difference to you in your contract. And a lot of people think, well, they're only going to pick references or provide references of people that have had a positive experience. No one's going to provide a negative reference. And while I don't necessarily disagree with that, I think it really bodes well if you can provide 2 or 3 names that have had positive experiences. Because look, every contractor, every vendor has problems or the potential to have problems. We all make mistakes, but that doesn't mean that we potentially shouldn't contract with you. And even in some of the best experiences with contractors, I can point out mistakes or problems that we may have had in the whole relationship. But, again, it's how the contractor or the vendor dealt with the relationship or that problem. What was the end result? At the end of the day, did you have a good experience? And, were they willing to stand behind their service or their product? So references are important. I can't say this enough. Insurance. Again, I think a lot of times people think we're going to require insurance. It doesn't really matter what it is, but they got to be insured. And they say, oh, yeah, we're insured. Please know that that's not enough just to be insured. Depending on the contract, and I'm going to get into this in a minute, the type of insurance, the limits, all of that is really important. And so it can't just be, are you insured? Yes. Consider using an RFP, a request for proposal. And that goes back to my statement that you want to make sure when you're reviewing vendors or pre-qualifying vendors that you're comparing apples to apples. You know, sometimes when you ask for 3 bids from 3 potential vendors, the bids really are quite different in the amount, and you want to be able to understand why. And everybody knows this, but cheapest doesn't always mean the best, right? And as a board member or a manager, you want to save the association money, but you also want to make sure that the person that's providing services for a cheaper rate is providing the same services and hopefully at the same quality, but maybe there are some other variances as to why they're able to do it. And again, I think part of that process is making sure you're comparing apples to apples. And that's why requests for proposals are, I think, helpful. And they don't have to be overly complicated. You know, you should just really understand, again, doing legwork at the beginning of this process. What is this contract for? Why do we need this vendor? What are the potential pitfalls if we do go down the path of doing this big construction project? In a high-rise or a condominium setting, if you know you're replacing the roof or the balconies, and you know that these are 40-year-old balconies, and that when the contractor gets in there and starts digging in, that there are potentially some problems that could be uncovered. Well, you need to consider that at the very beginning when you're dealing with a vendor. Does that vendor, know how to potentially deal with uncovering pitfalls or problems when they get into the contract? Or as soon as they see a problem, are they going to be like, look, we're not qualified to handle this, we're out, or we've got to leave the job? So having that discussion is really, really important. In terms of insurance and pre-qualifying insurance, some of the things that I've recently started doing when an association comes to me about starting the process of looking for a vendor is here, depending on the job, here is the list of insurance, the types of insurance and the policy limits for this particular type of contract that we think really we wouldn't recommend you entering into a contract without, right? So here's the list: general liability insurance, D&O insurance, automobile coverage, an umbrella or an excess policy to cover anything that might come up above and beyond the general policy limits. Those are all really important, and again, are dependent on the type of vendor that you choose. But what I like to do sometimes is just, hey, here's what we're looking for, and if you can't even off the bat qualify because you don't have enough insurance, then maybe that doesn't mean you're automatically off the list, but what can we do in this pre-qualifying stage to get the vendor to get more insurance and potentially adjust the contract price to make up for the additional insurance they need? And even sometimes vendors may not even understand the basis or the purpose of the insurance that we're requiring of them. But again, as lawyers, we're risk averse, and we try and think of anything that could potentially happen in a contract. And if a contractor or an employee or a sub is driving to the contract site and injures himself in the common area of the subdivision where the clubhouse is that they're working on, is that a potential claim that we're going to have to deal with? It happened on association property. And so things like that, again, understand that maybe they aren't often issues that you might have to deal with, but when they do occur, it's really important that you have proper insurance and safeguards in place to deal with that, instead of once you're way down in the process and with the contract trying to figure out now what do you do, especially if there's not proper insurance. And if you qualify or pre-qualify insurance, when you do get to the contracting phase, which is where a lot of contracts get bogged down in that process, that's one less hurdle that you have to deal with because you've already talked about it. And it's something that I think can easily just work its way out of the conversation or be a sticking point if it's brought up in the beginning. It's a really big deal, and it could be a deal breaker if insurance is not taken seriously enough. And again, depending on the type of contract, whether it's a minor repair or a major renovation, really important to have a detailed specs about the potential or the construction or whatever service it is in terms of the vendor that's providing the work. Because I think, again, what that does is potentially disclose damages or issues or pitfalls that could come up throughout the process that is really going to make a difference when you're talking about insurance and what policy limits you might have. The type of contract that you have is going to determine the insurance, and the potential for damage or pitfalls in that contract is also going to make a difference, a huge difference in the type of contract that we're going to recommend for insurance purposes. Again, related to insurance issues, really important to understand not just the type of policy or whether they're insured, but is it an occurrence versus a claims made policy? When does coverage get triggered? Is it based on the time frame that the contract was a part of the association's work? If the claim occurred during the time of the contract, then that's going to be different than 2, 3, 4 years later when something happens after the contract has ended and a claim occurs then. And different policies are written differently. Everybody should know, to work closely with your insurance company to make sure you understand, for the association's sake, what type of policy they have and what may trigger coverage. But again, more important in terms of vendor contracts to understand their policies. Not enough just for the association to say, are you insured? Great. We need to know what type of insurance and how claims are potentially covered. The effective dates of the policy are really important. Again, in terms of reviewing insurance, have legal involved, contact the association's attorney if you need help in reviewing certificates of insurance. Certificates of insurance are just a snap in time of the policy that the vendor might have. So potentially, again, depending on the type of contract, we may need to ask for a copy of the actual policy. Hopefully the certificate of insurance has what we're looking for and it complies with the requirements that we've asked. But again, it really depends. I've also seen certificates of insurance with effective dates that have expired. So they think, that they've got a current one that they're sending to you, but it's not. Really important to just pay attention to those minor details that could make a really big difference when you've gone down the contracting process. And making sure that the certificate of insurance matches the pre-qualification requirements. Again, very important. I've previously said, here's the insurance that I would really like to see with this contract. And then the manager or the board member sends me the insurance from the vendor. And, one of the boxes is checkmarked. There's no other coverage. Maybe they just have general liability. Well, immediately right off the bat, that does not match the pre-qualification requirement. So that's a non-starter, or it should be. And then that's when the discussion can hopefully commence and result in a more positive conversation in terms of, look, you don't have what we need. What do you, if it's going to change the contract price or the bid, how will it, and how can we be comfortable as an association, as a board, as a management team, to enter into an agreement with you, assuming that you're going to get the required coverages, and then you have to follow up and make sure that they do. Other relationships that really I've touched on these already. It's not just service providers like landscapers or construction contracts or pool companies that we're talking about. We're talking about every type of vendor relationship, and that means your lawyers, your accountants, and those professional relationships require additional insurance. We don't have necessarily something tangible that we're providing service for that you can see. It's more our opinion or advice. And for that type of contract, you need additional insurance, errors and omissions insurance that will cover those professional relationships. You're not going to be able to, in those service relationships, obtain some type of a warranty on that opinion or that service. The E&O policy is what's going to protect the association in that contract, and the standard default and indemnity provisions that we would recommend normally in a contract if you're working with a different type of service provider like a pool or a landscaper are, again, going to be different and may not work in a professional service contract or a professional contract with a vendor. So the type of contract and the type of relationship you have with the contractor or the vendor are really important, again, in determining the type of contract, the type of services, the type of insurance, whether or not indemnity applies, all really important parts of the pre-qualifying process. Again, a lot of legwork in the beginning, but I think what happens, and hopefully what should happen, is if you do the legwork at the beginning and you narrow down the field of contractors based on all of that legwork, it should be a pretty smooth process getting through the RFP and the contract. It should be, right, ideally. But all right, I think that's all I have. I'm gonna take a look real quickly for the questions, and I know I said I'd look at them, but I didn't do that, so I'm sorry. Before Noelle jumps in, see if I can answer some of these real quickly. How do you practically be careful around insurance other than just check COIs? Well, I think that I kind of answered this, just checking COIs may not be enough. It's not beyond your right as the association to ask for the actual policy. So go ahead and ask for the policy. Ask if they've had claims made on their insurance and have them disclose that. And sometimes it may be even worthwhile for you to say, can I contact your insurance company? I just have a few questions and you can deal with them directly. I don't know if a vendor is going to let you do that, but it might be worth it, just to be able to talk to the insurance company directly. Is workers' comp a relevant insurance to pre-qualify? And is there a risk if POA or HOA do not carry this? Well, again, depending on the type of contract, I absolutely think workers' comp is a very important part of any contract with a vendor. If the vendor that you're contracting with, let's use a pool company, has employees and the employee gets hurt on the job, ideally the employer's workers' compensation policy, insurance policy should be triggered, and any damage related to that employee would be covered under the employer's insurance policy. I would really be worried if a contractor that I enter into a contract with doesn't have workers' compensation if they have employees. I mean, that's probably a non-starter at the beginning. Whether or not the association has workers' compensation, again, I know I hate saying this, but it really depends, because the question really turns to how much control over the contract the association has. So if your manager is really overseeing the contract, and the employer can argue that somehow the association had a large amount of control over the contract and potentially issues related to securing the area, as an owner of the pool, the association has potential for liability if there are dangerous conditions that exist if we don't necessarily notify the pool company or get them corrected. So we do have a certain amount of control depending on the type of contract, and that's going to matter. So I would work with your insurance company, the association's insurance company, if you're about to enter into a contract, and determine if there's any reason why the association might need workers' compensation for that particular contract. What insurance should be required of professional services? I think the main one is the errors and omissions, and we can get you guys a list, but I think for professional services, that's really an important one. But all of the other typical coverages, I think, are important. And again, management companies, attorneys, they have employees potentially on site. So it really just depends on the particular contract, but E&O is a mess. And then one question about this being recorded. This is going to be recorded and available after we do end for the day, so we can make sure that this is made available. Okay, thank you all so much for those questions. I'm going to go ahead and turn it over to Miss Noelle, and she's going to, oh no, sorry, that's wrong. Noelle, I'm so sorry. I'm not going to turn it over. I lied. I was trying to finish up early. Okay, sorry guys, I've got a couple more slides. I thought insurance was where I ended. So I'm going to talk real quickly so I don't run over Noelle's time about indemnity and how indemnity is important in terms of pre-qualification. Indemnity is extremely important in terms of, again, as is insurance, if there's some type of a claim or a loss that occurs. If there's a claim or a loss, the indemnity provision will decide who's going to indemnify and pay for the defense coverage for that claim. And with a contract, really important that the contractor or the vendor indemnify the association for its acts or omissions related to that contract. A lot of contractors or vendors, well, not a lot, some are really interested in having some type of a mutual indemnity that is triggered. And while I don't necessarily have a problem with mutual indemnities, what I always tell associations is be careful, because if we're not providing, the association's not providing any service, I'm not sure why we're indemnifying the contractor. The contractor's the one that's providing the service or the materials, and so in our minds, logically, it would make sense that they would indemnify us for some type of a claim or a loss that occurs in connection with that service that's being provided. Really, indemnity provisions are important. That there's certain there's case law and that says that these provisions need to be conspicuous. There's specific language that we think is really important in an indemnity provision, and will hinge on the coverage might hinge on a particular word or words in the indemnity provision. So that's the indemnity is one, again, where I would strongly suggest that you work with your attorneys to make sure that it's written properly and covers a loss. Sometimes indemnities are only triggered if the claim is related to negligence or gross negligence, and you really want to be careful if the indemnity is trying to limit the basis for the loss, because essentially if the association is sued for being negligent or the contractor is being sued and only gross negligence is covered, then potentially the association is going to be left with having to defend itself, and that indemnity provision won't be triggered. Also important in terms of indemnity is there, how is the indemnity coverage provided? If the association, if there is a claim and the association has to have that indemnity provision occur, then how is that indemnity provision covered? Is there a right to some type of an offset? do we as the association have like a retainage, have the right to withhold funds to cure the default in that instance? So indemnity is a really, again, another important provision that has to be in the contract, and again, depending on the type of contract, varies. Touching back on the RFP process real quickly, I know I've said this many times and y'all are probably tired of hearing it, but it's a complicated process to do all of this legwork at the beginning. It's not complicated, I guess it's tedious. And I know a common complaint of managers that we hear is it's just there's too much time involved to do all this legwork. We know that there's 2 or 3 vendors in this area. They all do good work. I have other managers that I know in the industry at other management companies that have had good experiences. We get that, and I know that everything is a rush last minute, but I think at the end of the day, it's really important, again, to take the time up front and get it right. I don't have a problem with, the association using vendors that they know are reliable and have had great experiences with them in the past. But again, still really important to do the legwork. And Noelle's going to talk about why that agency partnership is really important in terms of protecting managers and making good business decisions as the manager for the association, and not just jumping into a contract because you know that you've had really good experiences with this particular vendor in the past. What we are really extremely fearful of, that we see more than I really care to tell you guys about today, is one, there's no contract that's even ever signed or looked at. I don't know if some of my board members are on the phone that I've dealt with this recently, but I have a $2 million contract that was a 3-page contract, and guess what? We're fighting about it. So, just because there's a contract doesn't mean it's a sufficient contract. So sometimes even a 3-page contract might as well be just like you might as well not have a contract. And then RFPs, where the RFP is actually what's signed and nothing else is signed. So that, the manager submits a RFP or the board submits one, both parties sign it with the intent that the ultimate contract is going to cover the terms in the RFP, and the contract never gets signed. And I guess there's an assumption that the RFP is the contract, and that's not true. An RFP is just an RFP. It's a request for a proposal based on those contract terms, and potentially, right, it can be used and it will be used, especially if there's not a contract, but you don't want the RFP to be the only piece of paper if you enter into a contractual relationship with a vendor. So I know it's go, speed, but really, again, take your time, explain to your boards, help them understand why it's important to spend an extra $1,000, $2,000, maybe even to get legal counsel and seek advice, have a contract reviewed, have the contract rewritten. And I know everybody hates that when I change a 5-page contract into a 30-page contract, but there's a reason I do that. There's a reason why those provisions are really important. Okay, and then I think my last slide, there's obviously other provisions that are important. Noelle's going to touch on several of them. I think in terms of my portion of the presentation, indemnity and insurance are 2 of my top important provisions, and really encourage everyone to work with legal counsel on those. Other provisions that we've seen are, covenants not to compete type provisions where there's a restriction or where there's a restriction of hiring employees of the vendor. If you really had a good experience with the vendor, you're not allowed to, for a year or 2, hire anyone that worked for the vendor. There's other provisions that require that the terms of the contract remain confidential. And we have to tinker with those provisions because, as you all know, if the association gets a records request, then we potentially have to disclose the contract. So confidential information could be in there, and we have to be really careful. Okay, I think I'm going to stop and give Noelle, sorry, a very quick, hopefully 15 minutes to get her part of the presentation done. Noelle's going to take it away. Thank you all so much. And we'll try and circle back with some questions at the end.
Yep, thank you, Sipra. I think I can do this in 15 minutes. So hi guys, again, my name is Noelle Hicks, and I am going to continue our presentation today and talk to you a little bit about the law of agency and principal. Sipra mentioned this earlier, and you might be wondering why it's important. But as a manager or a board member, remember you're not negotiating or seeking these services for yourself, but you're actually looking for them for the principal, who's the association. So it's really a good idea to have a basic knowledge, because it addresses under what circumstances the manager or the board member can legally bind the association, and then really who can be liable for damages. And a primary example of this is vendor contracts. These contracts are awarded in the name of the association, and they're either signed by a board member or a community manager for the benefit and the burden of the association. So you can really see why it's important that we give you just a little bit of background on agency and principal. So I'm actually going to take you to law school really quick and give you a short lesson on authority. Based on the employment agreement or the circumstances, a board or the manager, who is the agent, has express authority, implied authority, apparent authority, or no authority at all. And these are the different types of authority that the agent has to bind the association, who is the principal. And again, this is important because we really want you to understand why pre-qualifying is so important for managers or board members. If you understand the nuances of the relationship, it'll really help. So what do these terms mean? Express authority is specifically given to the agent by the association either orally or in writing. And examples of express authority and how it's granted can either be through the agreement between the association and the manager. It can even be in the declaration, perhaps in the bylaws or some other governing documents. With implied authority, this is where an agent has the ability to do acts which are reasonably incidental to and necessary for the effective performance of their duties. Now that's a very legalese way of saying that implied authority grants the agent the ability to make legally binding contracts on behalf of the association. So I'm going to give you a very basic example of that. If a server at a restaurant tells you that they can offer you a free beverage with your purchase of an entree, then they have made a contract with you on behalf of the restaurant, and the server's authority to give you that free beverage is implied, right? So that's pretty simple. With apparent authority, that means that the person's conduct gives you the impression that they're allowed to act on the principal's behalf. So we have this example is pretty simple too, but if you have a person who works for a company and under normal circumstances, they wouldn't have any authority to make decisions or to contract on behalf of the company, but then that company provides them with items like business cards or stationery, that could lead a reasonable person to believe that the individual has authority to act on behalf of the company, since these things were provided by the company, right? So then that means that if there was a price given, a price quote given, excuse me, or some sort of contract was entered into between that individual and a company, then it's going to be legally binding. And then finally, no authority is pretty self-explanatory. That means that the agent has no authority to bind the principal under any circumstances. Now that you know the different types of authority, you also have to understand how authority can be given. So the answer to that question can be based on the different circumstances, right? So for on-site management, the employment agreement should grant authority to act without specific board authorization. So that means that the manager wouldn't have to go back to the board each time it needed to do something on behalf of the board to get that specific authority to do that. Now, if we're talking about portfolio managers, then the contract should provide authority the same way for the manager to take action without specific board authority. But you have to remember, if there is no express authority, the agent could be responsible for any financial reimbursement to the principal. And so then whatever the case, however authority is granted should be clear and understood from the beginning, because it involves financial responsibilities, liability for damages, and so on and so forth. But the reason we're talking about this is because vendors are going to want the association's business, and they're going to go about different ways to try to secure it. Really though, we have to make sure that the way that they're doing that is an appropriate business transaction. They're going to attempt to tilt the scales in their favor, and then sometimes their actions can be viewed as ethical or unethical. And then some examples of ethical actions, obviously, the vendor is just simply doing a good job and they're sticking to the guidelines that are set forth in the contract. Or the vendor is entertaining the managers. And I'll talk about that in a little bit, the differences between entertaining the managers or perhaps a kickback or something like that. Maybe the vendor is providing gifts to managers or board members, but they're doing that under a certain dollar amount. But then you can also determine what vendors are doing to get your business by monitoring them closely and observing the quality of their work, or surveying boards to get their feedback on how they think the vendor is doing with whatever particular job that they've been given. So what about some of the actions from vendors that can be viewed as unethical? What about kickbacks? Well, what is a kickback? So essentially it's just a bribe or some incentive that's paid in exchange for selecting a personal vendor, right? But these kickbacks don't really happen frequently, although they're not completely implausible, and they don't always come in the form of money. So that's something that we need to really keep in mind. And this practice is obviously something that we should avoid when selecting vendors, but since we know that the POA world is very small, managers and vendors are going to work with each other often and they're going to develop relationships. So we just have to make sure that those are all above board relationships and that we're selecting vendors that meet the POA's budget and quality standards and not your own personal preferences. So I mentioned that kickbacks aren't always about greasing palms. Sometimes a kickback can manifest itself in other ways, such as nepotism. So if, for example, with nepotism, what if the association just had a rash of burglaries and manager Tina's brother, Tony, owns a security company? So she gives him the contract. But if Tina's brother has a stellar reputation and competitive rates, then this may not be that bad. But what if Tony's employees are always caught sleeping on the job, or they have terrible reviews online, or even their bid is higher than all the rest of the potential vendors? Then that's something that needs to actually, take a second look, and it might be a problem. Kickbacks can also come in the form of political hiring, awarding more contracts, and things like that. Providing gifts to the managers. And again, these are some things that are listed. Some of the things that we're talking about here are not necessarily bad on their face, but it is something that we have to consider. Still, there might be some situations where managers use the same vendors for all their properties. And is that wrong? Well, our answer is not always. And I actually think that the slides might be out of order here, but we have to consider, so I'll just go ahead and talk about this one now, but we have to consider when vendors are vying for your business, there should always be a written agreement with the vendors, and that agreement needs to state very specifically that they will not provide a gift of anything over of value over a certain dollar amount. The reason for that is because it could potentially be an unethical action for them to try and obtain your business. So we need to be clear that if they do so, if they do provide that gift that's over a certain amount, then they could be banned from bidding on future projects. So if a manager is, or excuse me, if a vendor is providing a gift, we have to consider why they're providing this gift and the intended recipient. And it could be that they're giving the gift to the manager exclusively, or are they giving that gift to the management company as a whole? Is the gift for the board only, or is it for the benefit of the association, or both? These are just questions to consider to avoid sketchy gift-giving situations. And so again, as I mentioned before, a kickback doesn't always happen, but sometimes it does. And so it's something that we have to keep in mind. It's important that we keep this in mind because, of course, that's an unethical behavior. We want to try to avoid these kinds of things. And as the slide mentions, the just because may relate to a number of properties being maintained. But again, recall that it's not the manager's personal preference, but you have to make sure that you are selecting vendors that meet the POA's budget and their quality standards. And so I mentioned nepotism earlier, and and different ways that kickbacks can come about. So it could be political hiring, it could be awarding more contracts than should really be awarded, profiting, providing gifts to the managers that are over a certain dollar amount, or even if the owner of the company provides a job to the manager's cousin in exchange for the contract. So we just have to make sure that the things that we're accepting or the relationships that we're keeping between vendors and managers or even board members is all above board. So to tie this all together and kind of put a bow on it, here are some things that we need to remember. And then these are our recommendations for pre-qualifying vendors for the association. So we want to recommend that managers have an employment manual that lists in detail some sort of permissible gifts, items that could be given from vendors, and then possibly examples of what's not permissible, so everyone is clear about what is and isn't acceptable. Vendors should always expect to enter into an agreement, as Sipra said previously. They want to make sure that they do that for all of their contracts, not just one or the other. There should be no picking and choosing. There should always be a contract involved. And the contract should include provisions for insurance and indemnity, as Sipra mentioned previously, annual gifts, so there's no room for confusion. It should also contain details of the services to be rendered, whatever the payment terms are, and any association-specific details that we haven't gone over that you are only familiar with because you work directly with the association. But as Sipra and I have both mentioned, contracts are very important, and it should include everything that has anything to do with what the relationship going forward would be. And then finally, as you can see from what Sipra and I have discussed today, there's a lot of work that goes into selecting the right vendor for the POA. Vendors come in all shapes and sizes, and the first one to come knocking is not going to always be the best one, but you have to make sure that you remember that you're acting on behalf of the association, so you have to make decisions that go along with that. You should make sure you look for qualified vendors that have some experience working with POAs. Sipra mentioned earlier about CAI being a really great resource to utilize. It's already got a lot of great connections with vendors and a directory that you can reference. So they probably already have vendors that meet your qualifications. And then finally, vendors have to be made to understand that they could be terminated if they fail to comply with the association's requirements that we've laid out for you today, and then any other internal pre-qualification requirements that the association could have. All right, guys, that is it for us today. Before we move on to the question and answer section, I wanted to just remind of the upcoming webinars that we have. So we're going to be talking about virtual 209 hearings on Wednesday, August 19th at 11:30. So you want to make sure that you sign up for that. It's going to be presented by Leah Burton, a shareholder in our San Antonio office, and Paul Gaines, an associate in our San Antonio office. And then on Wednesday, August 26th at 11, we're going to be talking about annual checklists, and that will be presented by Clint Brown, who's a shareholder in our Austin office. And now, if anybody has any more questions, I think we can look on our question and answer section just to see if there's anything else we need to cover.
Yeah, I think we're running out of time here, so I'll get to these if I don't. But let's see. I've got a couple of questions about if a claim is paid against the POA, does the insurance provider seek recovery of the funds from the association? I'm not sure I understand the question entirely, but the purpose of insurance is to provide coverage for potentially defense costs, so attorney's fees, and then any damages. And depending on the policy that gets triggered, insurance should provide the coverage for those costs. Again, depends on the type of insurance that's being triggered. But I think what maybe the question might be is if everybody knows potentially there's a deductible that the association has to meet. So the association will be out some funds if insurance is triggered, but depending on the way that the claim is framed and the result, if it's a breach of contract, maybe the insurance provides, again, defense cost coverage, but it won't provide coverage for the claim, the amount of the damages that get awarded against the association. So it depends. Regarding one-time jobs, the vendor usually submits the terms of the agreement with an estimate. Do we need a contract of some sort for one-time jobs? Absolutely. There's no distinction in my mind between a one-time job and an ongoing, a contract that runs over a year. Whether it's a one-time job or whether it's a long-term contract or job, I guess, all of them should have contracts. And, we're, as the association's attorney, we're going to try our best to not create a 50-page contract for a $5,000 job, but like I said, even in a $5,000 contract, there could be some major damages depending on the claim. So important to have contracts in any type of situation.
If you look at the last question too, Sipra, that ties in with the one that you're answering now.
Okay, perfect. Should the association really be entering into contracts for all work, for example, $200 fence repair as opposed to a signed proposal? Is an alternative to get vendors who the POA frequently uses to enter into an MSA type contract with WOs issued under it. Yeah, I certainly think if it's under $1,000, I don't know. I mean, it really just depends on, again, the type of contract. You're not going to want to spend $500 on legal fees on having me review that contract or whatever it is. So yes, there are probably some where you're going to say, invoice me for repairing the fence, and that's it. The contract's going to just be the invoice, and I don't have a huge problem with that necessarily. But again, depends on the extent of the work. Is there a big hole in the backyard that this guy could fall into? I don't know. I'm trying to be funny, but use your best judgment. And if all else fails, check with legal counsel. Call the association's attorney and say, look, I'm about to, ask a handy guy to come do $1,000 worth of work on association's common area. Is that something that we need to have a formal contract with? And what are your concerns? And at the very least, have a conversation about it so that we can guide you the right way. All right, guys, I think that's about all we have in terms of time so that we don't take up more than our hour allotted. Noelle, do you have anything else to add?
I was just going to say, for the other questions that are here, we'll just answer those individually.
Perfect. Yes, we will get back to, we've got names and emails for everyone, so we will get back to you. Thank you all so much again. It's been a pleasure, and please tune in for the webinars that are coming up, and we hope to continue to provide some good education for you guys. Feel free to reach out to either me or Noelle at any time, and we or any of the attorneys. All of our contact information is on our website. Hope everybody stays well. Thank you.
Thank you, guys.